There's a lot of discussion as to whether individuals who are involved in what I will describe as a leisure activity are able to sue an owner of property if they are injured. Now, the law in New York State is pretty clear, and the doctrine is called primary assumption of the risk. That if an individual is involved in a sport, that individual is precluded from making a claim, unless, and there are exceptions to that, the owner of the property has materially altered the known risks to that sport. With respect to leisure activity, I would say ice skating, things like that, the rule is a bit different. With respect to leisure activity, the premises owner is only responsible initially if it is a premise that is not generally the type that is used for that type of activity. For example, if somebody's rollerblading in a park, primary assumption of the risk would apply. If somebody is rollerblading down my driveway, it would not, because my driveway is not somewhere that is generally used for that type of activity. Now, again, if the premise owner has materially increased the level of concern with respect to the property, then they can be held liable. Another issue that arises on a regular basis is whether that assumption of the risk applies to people who are not engaged in the actual activity, but they're on the property in any event. A person who's walking at a ski resort and falls and slips and falls on ice. A person who is at the ice skating rink and slips and falls on the premises, but they're not ice skating. And the answer to that question is primary assumption of the risk does not apply in those situations. Those individuals are treated just like anybody else with respect to a premise liability case and their ability to sue or recover for the injuries and damages that they have sustained.